We'll hear from Dr. Chitra about the scheme of standard essential patents, how they benefit, lead to benefits.
Yeah,
So,
another controversial topic. Sorry for bringing all the controversial topics here. So just to get a little more energy into the room, can some of you who know about SCPs just please put your hand up, so I know how much to speak and how to structure my thoughts. Thank you, ma'am. And okay, at least we know a few people. For the others, I'm going to keep it a little basic so that we can go over it a little bit. So today I initially thought of talking about the legal framework surrounding SCP licensing and innovation ecosystems and speedy dispute resolution is the topic I had. But before I go into the topic, I'll keep it a little high level, keeping the audience in mind. I'll talk a little bit of the company I represent. I work for Philips in India. I've been with Philips for about 10 years now and handle most of the litigations in India. And the good outcomes you see and the not too good, I'm solely responsible for the bad ones as well. So that's my responsibility. Okay. No, Singh has done a pretty good job for us, so I wouldn't say that. So just to talk a little bit on the organization itself, and it is not to talk about the company per se, more about what really goes on when you're having an organization where you spend, when you get patents, right? So that is an investment spend involved here. Almost 9.5% of our sales goes back into innovation. Also, I think we have a reasonable position in 2024. And we are also heavily into software-based innovations for medical technologies. Clarivate's top 100 global innovation for 11th year in succession. I think we also got it in 2025, making it the 12th year. And the thing I wanted to talk about a little bit here, I don't know the audience we have, is that all of this patents that you see did not happen overnight. The first patent that Philips filed was around 1905. I think barely many people would have known what a patent is about. So it started with something like the first patent. It was on I don't have the subject here, but 1994 introduction of metals in X-ray tubes. There are several new things, including 1927 the Philips radio, and then there was the electric heater, the first electron microscope in 1947, and then the first Philips TV in 1950. And then, and every time if you see, we have constantly tried to innovate ourselves, the company itself, and stay relevant. The reason I'm saying this is because if you forget that you're serving a customer at the end of the day, the consumer who's going to use your products, then you will lose focus if you're just innovating for the sake of numbers. So when you're innovating, it has to be for a product which a customer will use. Customer always has to be at the end of your in your radar, a person who will use your innovation. It has to be useful, it has to be inventive, it has to be something that can have industrial application, all of that. So 2019, we are into pathology solutions, which are all mostly software based. 2020 radiology operations, 2021 spectral CT. So you see we are constantly reinventing. The only reason I'm saying this background is because to say that, why do we have SCPs? Why do we do SCPs? So what really happens, we need to go back to our the business models that we have. Some patents that we develop, they go into our core products, like you have a MR or CT or ultrasound, they go into it. But a company that is almost 130 years old, what has happened is we have spent a lot of time and energy in developing technologies which are top class, but really not that we want in our products that going forward. So what do you do with the legacy patents which are so high quality? We thought, okay, let's license them out to somebody who may be able to use them. So logical step is, when you have a patent, you spend money in creating them. You want to monetize one way or the other. One way is, of course, you must be knowing the monetization models. One is, you have it in your core products. Other way of getting revenue is through your licensing models. If you don't have really you're a late entry into the market, then you do either cross-licensing or, you just have an exclusive, you kind of defensive model. You create a patent ticket just to stay safe in the market and do your work. So those are basically the four things. But I'm here talking about the second quadrant that I spoke about. It's an exclusivity model which goes for co-licensing. Now coming to why do you need standards? Let's go back to the basics. So you need standards because it just makes a life easy. And why? Let's look at examples. The the railway tracks, for example, as far as I know, they're one of the oldest examples of how standardized tracks. See, if you had different tracks in different cities in India, or you had different tracks in different parts of the European Union, for example, it would make impossible to travel across cities. So you needed some harmonizations, you needed some standardization so people could benefit from the, something being set, this is going to be the measurement of the railway tracks. And then coming to the new age, you have for example, the electrical sockets in India. Even now, I think we have a lot of challenges when we travel from one country to the other. The voltage is different, the sockets are not okay, it doesn't work. Sometimes each pin is different. We still use the different multi-socket, and sometimes we forget it and you're in trouble when you're in a different country. So the advantage, what would happen in a world when all the sockets were similar, you would just go and plug and get to your job much faster, right? So there are advantages to standardizations. The standardization and SCPs became more prevalent when we started entering the telecom space. So when we entered the telecom space, we had things like, now telecom, the way it is, it's got no boundaries, right? There are no borders, no countries. You want to be able to use the same phone when you're in India, wherein you're in Europe, you're in the US, vice versa, because you can't keep buying a new handset, these are expensive, you would not want to do that. Also, it's inconvenient. So when you do this, there was a need to standardize. In the telecom space, it was HC. Similarly, we have IEEE, we have other SSOs which took the initiative, sat together, decided to evaluate all the technologies and decide what was the best for the customer, and decided that, okay, we are going to develop this pool, in a way, the pool, let's say you say 5G, 3G, 4G, whatever consortium, and 3GPP, for example, and you say that, okay, and now we are going to have companies, individuals, whoever wants to come and talk about the technologies, and it was evaluated. It was decided that these particular technologies will be adopted into the standard. So you see the amount of work that went in the back end to bring to something to the market, which leads to a technology that can be adopted widespread and which can also be affordable, it can be convenient for the customers. Now, other examples of standardized technologies for your information and reference are like, for example, after 3G, it has been 4G, LTE, which is also called. There's 5G, there's Wi-Fi, there's Wi-Fi 6. And then there is going to be things around IoT, JPEG, MP3, MP4, and Apple developed its own ecosystem, the iOS. And the advantage of having a standardized technology is interoperability. I'll give you an example. I think when we developed the 3G, 4G technologies was before we actually thought it would be used in the medical systems, or at least the concept was not fully evolved, till we feel, oh, the technology we developed as maybe cellular can also be used in a medical systems, for example. The monitor and the console talk to each other. The patient can be seen from a central console. Multiple patients can be monitored by the doctor. There are several advantages to those technologies, which you don't realize immediately sometimes. So advantages of standardization, as I said, as interoperability. There's reduced cost, increased safety, and improved efficiency for everybody concerned. Now, these are the standard essential patterns which go into the standard. Now, coming to this, so I'm just explaining this a bit because sometimes people get confused between an SCP and non-SCP. SCP is not different from a regular patent. It is a patent, basically. It's a standard essential patent because it carries a higher responsibility that the person who's having those patents has to make a declaration saying that we will license it out on fair, reasonable, non-discriminatory terms. Why? Because you're holding a technology that is used by everybody, right? You can't say, I can't give you a license, I will not give this person, I will give. We need to be able to give to everybody, but being reasonable so everybody can adopt. So that is the essential principle that was developed for standard essential patent. So SCP is generally a patent that protects technology that is essential to implement a standard. A standard is an agreed or established technical description, technical standard, or technical, the process of what was involved in that, product, services, or ways of doing things. Examples are, the mobile phones, wireless connectivity, navigation systems in cars, smart meters, And once a technical standard has been agreed, manufacturers are required to make the products available across. Now, you would have noticed now that something that developed as a wireless technology for the phone was very convenient. You have a charger, you leave your phone. Then there were people driving on cars and they wanted to take phones. So they said, okay, let's put the wireless technology into the car so that when you're driving the car, you leave the phone on the, in the dashboard or someplace where there's a slot provided and your phone is charging while you're driving without a cable. So there is a definite advantage of time and money, efforts people spend in developing such technologies. So therefore, it was important to develop a framework to license these technologies, obviously, right? And then came the smartphone wars, because then there were so many people, there were different companies in the world, because that's what you probably hear about. There are different companies, they're having different, now cell phones don't have one product, one patent like the pharmaceuticals. There are so many parts of a cell phone, sometimes thousands or even more, where different companies can hold different parts of the patent. And then when a company, for example, gets a notice letter from one company, they think, oh, I've taken a license, and then another company goes because they have another part of the, of the phone which they have technology to. So it becomes very confusing sometimes to the end customer that how many licenses do I need to take? Will I even make money from my business? And therefore, the concept of the pool was developed, very similar to what Archana said, the pool concept, so that everybody goes to the pool. The pool manages the license in a common way. So then, now when I spoke about FRAND, you make a declaration, and the difference between an SCP and non-SCP, basically, for the understanding of people, is that when you have a normal patent, you can always go to the court and say, look, this person is using my technology without my permission, and I need an injunction. This really is very helpful, because you don't want the other person to make money, because you're in the market with your products. In SCP, it's not like that. You cannot, courts globally are sometimes amenable to injunction. Sometimes these days we find that they're also reluctant to give injunction. And sometimes the injunction is the only way to get the other party to the negotiation table, If you had an ideal mature world where somebody felt that I'm using somebody's technology, I'm living in somebody's rented house without paying a rent, I need to at least have a conversation with the owner, it would be a much peaceful world. But many times it's not. We don't live in an ideal world. And therefore there are lawsuits and disagreements, and then the injunction sometimes becomes a trigger for the other side to come and talk about it. In India, I think we've been quite successful in convincing the judges in most of our cases. We didn't get an injunction, but in India, we have something known as an interim relief. The reason the interim relief works in the Indian system is because the court systems takes a little longer than other countries, and judges have been kind enough to know that in the meantime, somebody needs to be incentivized for innovating, and they've been considerate enough to give something called the interim pro tem, as we call, in the pendency of the suit, so there is some trigger to negotiate. Typically what happens is the moment the pro tem order is out, they start talking, and then we are able to close the licensing deal. So coming to the reasons for litigation, because there is many times the difference of opinion between the licensor and potential licensee about the different terms when we say FRAND, fair, reasonable, and non-discriminatory, because if you think about it, each of these words are highly debatable. They've been disputed and in many courts globally about what is fair, what is reasonable, what is non-discriminatory, and all of that. Coming to FRAND basics, for the people who don't know much, and I apologize if there are people who know more, I'm just trying to keep it at a basic level, is that it's mostly about balancing interests and obligations, and it's stopping abuse of dominance. Okay? Now what can happen is if you have 10 houses in a place, and that's the only houses available in a city, you would end up charging more, right? Sometimes you have the power and capacity to charge what you want. Sometimes there is a fear from the other side saying that there's abuse of dominance. It happens. And then that is for the courts and other people concerned to take in all the facts of the case and decide, was there an abuse of dominance? Was there a hold-up? Or we call it as a hold-up when the patent holder is not being reasonable. We call it as a hold-out when the so-called licensee is not willing to come to this table or is not giving a counter offer that is reasonable. So I'll then go on to the basic, a little bit, only on one slide I have on how the courts have so far, even Indian courts have decided the same thing. There is something which has been agreed upon as the basic negotiation expected between a licensor and licensee in a FRAND case. So what the court decided in the case of Huawei ZTE, and then there were two cases, the Syswell Hire 1, Syswell Hire 2, in I think it was Germany. And then of course in India we have the Ericsson Lava case where this was deliberated and a very detailed judgment was passed by the division bench. So the premise that is there now at a very broad level is that the STP holder typically tells the supposed implementer that you are infringing, I have a technology, you are infringing my technology and you have to pay me so and so license rate and whatever, etc. Right? That goes into the notice letter. And then the other side either is willing, accepts and wants to come and discuss, or quite often they don't want to even see you. They avoid your emails, they don't want to talk to you. All that happens. So this is called as unwilling behavior in the language of the court. And then there is the step 2 is you need to give them a FRAND offer. The other party then comes up with a counter offer, and the counter offer can be rejected if it is ridiculously low. Or, sometimes in German courts, for example, you are supposed to provide a security, a token security if the receipt is need to be provided. And all this happens. And sometimes if the FRAND offer is very high, it can be considered as abuse of dominance. If not, sometimes the court says, no, the other side has been very unreasonable, and then the injunction order or a pro tem, as we call in the Indian courts, is passed. And usually after this, it's a trigger for settlement, or there's an appeal that is then, go to the next level of the court to decide. So I think I'll stop here so that we can then open to questions.
So just one comment from my side, that if we see case of Ather Energy, they developed the electric scooter, they kept their standard for charging, they wanted to keep it open. So there is a clear-cut benefit for the consumers in the sense that all scooter manufacturers can have the same standard, and it like the consumers' range anxiety will not be there because they can charge it anywhere, any place. So there is a clear-cut benefit here. So do you see any other systems in maybe your sector or pharmaceutical? Because maybe CSIR was having open source drug discovery. So can you throw some light, both of you maybe?
I think when the technology is widespread and you have products that read on the technology, it definitely makes sense to open it up, right? So, for example, if I have a shop and I give access to the street to everybody, I tend to benefit because people who pass the street might come and take something from my shop. I'm just giving us a very rough analogy, but I'm saying that the motive is usually profit. When you're giving something, especially when it has entailed a lot of cost to develop, then you would give a part of it free so that then you get money in some other way. Usually that is the thinking. And I'm not saying it's right or wrong. I think it's more about the context, how it is applied.